Senator Audette. Madam Speaker.
Ever think one day that we would be in this chamber when our moms, Don Lavelle, our moms stood up against the government, against the Indian Act, but also against many men who were chiefs that time. And that is very important to talk about this chapter. We still taste that bitterness. But the beauty, the healing, and the power that I saw today, this room was and still filled by chief demanding that we go further than what S-2 is proposing. The second generation cutoff. The chief are asking. For me, I try to stay in a place where the emotion, I'll keep it for later. But the Wolverine in me, we say carcajou, I want to make sure that I honor what your mom did, very alone, to walk till the Supreme Court of Canada, and then open other doors for other women, such as Madame Lovelace, our sister from this chamber, and so on. Who paid for that? I guess they did. It was hard. It was hard. So it's very, very, very important for me also to acknowledge that finally we have men, we have women, former chief, elected chief, friends are saying, push this bill as much as you can because the momentum is here today and now. We are from that lived experience, so let's not forget that. And we try, like the women, the famous 5 women, try to get inside parliaments. Same for us. Women affected by the Indian Act, and still today. And I try to smile. I try to walk here with dignity and say, yes, it is there in my blood. But for me, I stand strong today because I believe this report with the amendment presented by APA should be adopted. And then, third reading. This is what I believe. I would never think that we have to argue for that part here in Canada, ever. So it wasn't in my speech, but I needed to share that. Very important, when the bill arrived, the delay was short. The BC court, we didn't have the same time that we have today. Very transparent, very honest. If amendments are there to improve and there's a willingness, I'm willing. You can quote me, it's in my second reading speech. But now we have more time. We have until April, we, the 2 chamber. The committee, and as the sponsor of the bill, we made sure that we respect that time frame, that delay. We made sure that we have a diversity of who will come and say, we agree or disagree, or this amendment or not this amendment, or we don't like S-2 at all. We had one voice, and it's important for me to mention that voice. But also, it's important for me to remind all my colleagues what they said about duty to consult. And I'm going to say it in French because minutes count. L'obligation de consulter.
The duty to consult, it's a constitutional obligation, and here I'm going to refer to some documents, some guiding lines from 2011, the 2011 guidelines for the federal public servants, part 2, and it says the duty to consult stems from common law based on the judicial interpretation of the Crown's obligations in the context of the established or potential treaty rights, potential Aboriginal and treaty rights of Indigenous peoples in Canada, recognized and confirmed in Section 35 of the Constitution Act 1982. So this is the paragraph from the guidelines. And with the spirit of renewal, 2022-2023, and this was presented in a report as being part of provisional guidelines. So it's important to say things as they are. These are not officially adopted yet. And the part of women in this consultation process, when we talk about modern treaties, government structures, there needs to be an analysis based on genders. So that's a fight we fought. Now, for decades, the courts have reminded us of an essential distinction. Section 35(1), the existing Aboriginal and treaty rights of the Indigenous Peoples of Canada are hereby recognized and affirmed. Now, we don't hear this very often, but I'll go ahead and share it with you. Again, in Section 35, but 4 this time, it refers to equal guarantee of rights for both sex. So it says, notwithstanding any other provision of this Act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. So this is important for me because in our protocols, women have their place. Colonialism shook that up, but we know that we have our place. And this allows us to remind this to our peers to reclaim our places in this context. Now, I participated at the United Nations to all kinds of debates and discussions on UNDRIP. We had a room full of people speaking Spanish, and we were trying to find a common language, and we were talking about the articles of UNDRIP, the declaration. So I turned to the person next to me and I go,
For me, in Spanish, because we're debating on which article, what we should adopt, the language, in brackets, or remove the brackets. And she says, okay. So I say to this big crowd of Indigenous people around the world, you know what you're doing? It's very important, but I want to read and I want to see and I want to make sure that women are also included in that declaration. That everything that it says in those articles, it's applicable to men and women. They applaud. I thought it was consent. I get this on my shoulder, come outside, in English. And that time my English was more rusty or not good. I had to argue with a chief because the impression that if we come and say women, it's going to dilute the declaration. Those days, many moons ago. But today, those words are also in that declaration. So I'm confident that if we do a real and sincere process with the First Nation, the nations here in Canada, we will keep in mind in our spirit many protocols from our nation, from the Constitution, and from UNDRIP. Alors, c'est des outils super puissants.
So these are very strong, powerful, and necessary tools. Now, it becomes problematic in the debate we have been having recently, and I'm going to approach this very honestly. And we're trying to expand the duty to consult in areas where we have not had that before when we talk about the discriminatory provisions. Now, Senator Morrow said that that's not where the debate lies. It's rather the nation-to-nation aspect of things. But I think it's dangerous that we adopt this approach because we're turning it into a tool of obstruction by having this rhetoric. by saying, as the government, we have the responsibility of consulting, etc. And I've also heard the following.
Nothing. I try. I'm not a lawyer. I'm a super no-cum, super mom, and I hope super senatrice. But I read many, many Supreme Court decisions, English, French. None of them said, you need to consult on discrimination. You need to consult on equality according to the charter. And I'll say that in French to make sure I'm not misquote. Rien dans la jurisprudence de mes lectures de cour.
Nothing in what I read in the jurisdiction of the Supreme Court makes it compulsory that Section 15 of the Charter be used to delay reparations that are guaranteed by the Charter. So it is important that when we are rectifying injustices that have been recognized by the tribunals, the major tribunals, and these are constitutionally established injustices, Parliament has to be exercising its duty. We are Parliament, and we have to exercise our duty. Now, you have heard the sections of the Charter from my colleagues. Honorable senators refer to different court decisions. Now, what I'm going to remind you, because time is precious, is the following, that each tribunal that we have heard about that looked into the statutes, discrimination between men and women under 612 and 622, whether this is done timidly or in a striking fashion, all of the decisions are telling us that Parliament can do more. We can do more. So that's what we are trying to do here. And that's what we are. That's the key message we're trying to communicate. We have this responsibility. So to go to the Supreme Court of Canada or to an appellate court or to a first instance court or to the United Nations, you are looking at financial burdens that we don't have as women or as different communities. So that's a challenging discussion and debate to have too, because we can do as such that our mothers and relatives will go, okay, finally we are recognized. So there is something very nonsensical for me. You can say it's doable, but emotionally and politically, well, how are we required to do this as parliamentarians? It's simple for me that we go ahead and propose something that's coherent and that is loyal to the instructions of the courts, because it's a constitutional obligation, because since the McIver and the Shino tribunals and courts have shown us a path and encouraged us to do more, and this shouldn't be a political choice. It's a question of fundamental equality. And for me to be here in this chamber and to impose a complex consultation on each reform, it is as if you are giving an implicit little right to veto, which the Supreme Court refused in the Haida versus Canada case. So we need to keep the two things separate. We need to encourage the other procedure nation to nation. It shouldn't be starting from the Indian Act. The Indian Act used to be called the Gradual Emancipation of the Savages Act. So it was an assimilation policy. So it's not government autonomy. It's not a right coming from the treaties. It's not an indigenous right. It was a policy so that I no longer exist. So we won part of the battle over the years, but now there's another layer that comes into play to control who is indigenous or not. So we are Mohawk, we're Innu, or we're other groups, and this has quite a substantial impact. So in this chamber, let's imagine how we're going to live through this emotion.
Debated in this chamber, in committee, something that the court said there's discrimination. We need to change the Citizenship Act. what it says, in my view or my world, we always, and we were always welcome. Quebec, it's an Innu word. Quebec means, come, get off from your boat. So we were awesome Innu people, I can tell you. But in this chamber, when I saw C3, which it was C71.
Honorable collègue, le temps.
Honorable colleagues, the time has expired. Are you asking for additional time? 2 minutes. Is leave granted? Senator Audette. Thank you.
So the parallel for me was we will welcome 2 second generation, how do we say in English, who was born outside of Canada to be able to apply and become Canadian citizen. Only one parent rule. When me, if I have 1 children or 2, I have 5, I have to prove who is the father. 2 parents rule. Why? Here in Canada, we say yes to people that was born outside, and we're giving them that right. And Minister Galmasti, her government, her nation, the James Bay Agreement, since day 1 of that modern treaty, only 1 parent rule. So I know it works for Cree people, Naskapi, and under this treaty, modern treaty, and also for people that will come from outside because they have a grandparent and can apply to be a Canadian citizen, but not us. Please think about that. Thank you.